Good morning. This is Bob Dunleavy, and joining me is Nadia Lampton. We are experienced labor and employment law attorneys at Taft Law who have been dealing with COVID-19 matters since the onset. We welcome you back to speak about the major developments of the Department of Labor issuing 124 pages of regulations explaining the Families First Coronavirus Response Act. These regulations affect millions of workers now eligible for paid time off as of April 1. We are bringing to you the most current information about these regulations and other breaking developments. These are labeled temporary regulations in order to avoid the traditional comment period customarily required. As you may know, regulations are used to explain the law, and so now we have 124 pages to assist in the explanation. So for the next 50 minutes or so, we will discuss two components of the Families First Coronavirus Response Act, which are one, the Emergency Family Medical and Leave Expansion Act, and second, the Emergency Paid Sick Leave Act, and we will briefly answer questions at the end of the presentation. We will also discuss the new State of Ohio shutdown order, which has been modified. As always, this will be a straightforward, practical presentation providing the advice employers need to know. In prior webinars the last 2 weeks, in which we have spoken to almost 2,000 employers across the Midwest, we provided advice on do's and don'ts for employers in complying with the Act. Some of that advice has now changed due to the issuance of the regulations, and we will note those changes for you. In addition, some of the Department of Labor's questions and answers which were published have changed as well. If you care to advance a question during the presentation, merely text or email it to Nadia at the address on the screen. We ask that you mute your devices at this time. So with that housekeeping out of the way, let's get started. Nadia, will you first address the paid sick leave?
Thank you, Bob. Good morning, everyone. Thank you so much for joining us. We have so much information to cover today, so we're really just going to dig right in and get started. The Families First Coronavirus Response Act, it was signed by the President on March 18th. The Department of Labor issued preliminary guidance on March 24th by way of legislative Q&As. And then they issued the agency regulations that Bob just discussed on April 1st. So just 2 days ago, and April 1st happens to be the effective date of the Act. So we haven't had a whole lot of time to digest them. Things are evolving rapidly, but we want to get you the most up-to-date information as possible, as you are probably being inundated with employee questions and leave requests already, even though we're just a couple days in. So effective, as I said, on April 1st, 2020, just a couple days ago, covered employers are now obligated under the Families First Coronavirus Response Act to provide emergency paid sick leave and partially paid expanded FMLA leave for certain qualifying reasons related to the coronavirus emergency. And these paid benefits are subject to specific tax credits and reimbursements. And we're going to get into both the emergency paid sick leave and the emergency FMLA. On the next slide, we're going to deal with the covered employers. And this is the analysis to determine the covered employers for both the emergency paid sick leave provision and the the expanded FMLA provision. The benefits for the emergency paid sick leave and the expanded FMLA must be provided by all employers with less than 500 employees. This includes all full and part-time employees. It includes temporary employees. It also includes day laborers that are supplied by a temporary placement agency or other company if there's some ongoing relationship there. It includes all employees in the United States, DC, or any U.S. territory. So any foreign-based employees are not going to be included in the count. Also not included in the count are independent contractors and employees who have been laid off or furloughed and have not subsequently returned to work or been reemployed. Note that it covers private employers, nonprofits, and religious organizations and public agencies employing at least one person, including certain colleges or universities that are considered political subdivisions. There are some exemptions with the EFMLA that Bob will talk about in a little bit. Separate corporations may also be considered a single employer if the two entities meet the joint employer test under the Fair Labor Standards Act or the FMLA's integrated employer doctrine. For those specific analysis, you can contact Bob or I at a later date, but just know that separate corporations may be combined to be deemed a single employer under those theories. There are some exemptions and exclusions, though, to the covered employers. So the exclusions are at the employer's option. An employer whose employees are healthcare providers or emergency responders may exclude that employee from the obligation to pay emergency paid sick leave or the expanded FMLA. For purposes of eligibility exclusions only, so not for diagnosis related to a qualifying need, just the eligibility exclusions, a healthcare provider is a very broad definition, and it includes anyone employed at a doctor's office, hospital, healthcare center, a clinic, a post-secondary educational institution that offers healthcare instruction, medical schools, local health departments or agencies, a nursing facility, a retirement facility, a nursing home, home healthcare providers, any facility that performs lab or medical testing, pharmacy. It also includes individuals employed by an entity that contracts with those institutions to provide services or maintain the operation of the facility. So as I said, it truly does encompass a great number of employees so that the healthcare industry does not see massive leaves during this very critical time. Again, this exclusion, this definition of healthcare provider is only for purposes of eligibility exclusion. It's not, later on we're going to talk about diagnosis related to a qualifying need to take the leave, and this definition is not used for that purpose. With respect to emergency responders, again, for purposes of eligibility exclusion only, emergency responder is also a fairly broad definition, and it's going to include anyone necessary for the provision of transport, care, healthcare, comfort, and nutrition of patients. And it's going to include military, National Guard, law enforcement officers, correctional institution personnel, firefighters, in addition to the traditional emergency responders that we would think of in a day-to-day sense. So those are the exclusions, and again, it's at the employer's option. We also have a small business exemption, and the law provides this exemption for small businesses with fewer than 50 employees. However, I will caution you, it is unlike other small business exemptions that we see under related laws. The small business exemption here is fairly involved. Employers, including religious and nonprofit organizations with fewer than 50 employees, may qualify for an exemption from the requirement to provide leave only when the imposition of those requirements would jeopardize the viability of the business as a going concern. To be entitled to the small business exemption, an authorized officer of the business has to determine that one of three conditions is present. And the three conditions, as I said, are pretty involved. There's a high bar to meet the eligibility for the small business exemption. The first condition is that the leave requested would result in the small business's expenses and financial obligations exceeding their available business revenues and would cause the small business to cease operating at a minimal capacity. The second condition is that the absence of the specific employee requesting the leave would entail a substantial risk to the financial health or the operational capabilities of the business because of that employee's specialized skill, their knowledge of the business, or the responsibilities that they have with the employer. The third condition is that there are not sufficient workers who are willing, able, and qualified to perform the needed work at the time and place needed to perform the services provided by that particular employee requesting the leave, and that those services are needed for the small business to operate at a minimal capacity. So one of those three conditions has to be present in order for the small business exemption to apply. If a small business denies paid sick leave or expanded FMLA leave to an employee because the employer has deemed itself a small business based on one of those three conditions, the employer still has obligations under the law. It has to document that a determination has been made pursuant to the criteria we just discussed, including the facts and circumstances that warrant the denial of the paid sick leave or the expanded FMLA that was requested. And that documentation has to be retained by the employer for a period of 4 years. Also, the employer, even if they're exempt under the small business exemption, still is required to post a notice, the required Department of Labor notice. If you don't have that notice, contact Bob or I. We will provide you the necessary resources. Okay, the next slide is really where we're going to dig into the emergency paid sick leave. The emergency paid sick leave requires employers to provide up to 80 hours of paid sick leave for full-time employees, which includes employees who are normally scheduled to work at least 40 hours each work week. Note that this applies to all current employees, regardless of their length of employment, taking into consideration the exemptions and exclusions that we just discussed in the previous slide. So all current employees, regardless of length of employment, can obtain the paid sick leave benefit. Full-time employees are going to get up to 80 hours of paid sick leave, and the full-time employees are those who work at least 40 hours each work week. If an employee does not have a normal weekly schedule, they'll be considered full-time if the average number of hours per work week that the employee was scheduled to work, including any leave that they've taken, is at least 40 hours per work week over a period of time that is lesser of the past 6-month period or their entire employment, whichever one is less. The emergency paid sick leave benefit for part-time employees is the number of hours that the employee is normally scheduled to work over 2 work weeks. So if the part-time employee has an irregular weekly schedule, then we're going to calculate the employee's time just a little bit differently. If they're employed for less than 6 months, the leave is equal to 14 times the number of hours that the employer and employee agreed upon at the time of hire. If we don't have an agreement in place, even just a verbal understanding between the two, if we don't have any agreement, then it's going to be 14 times the average number of hours per calendar day that the employee was scheduled to work over the entire period of employment, including hours the employee took for leave of any kind. Note that emergency paid sick leave can be used intermittently, but only for certain reasons and only if the employer and employee agree. So absent employer agreement, we cannot use the emergency paid sick leave intermittently. The agreement to use intermittent leave may be memorialized by a written agreement, but it's not necessary as long as the employee and the employer have a clear and mutual understanding between them about the intermittent leave. The intermittent leave can only be used for leave to care for the employee's son or daughter whose school or place of care is closed, which I will discuss with you in just a moment. Once an employee takes emergency paid sick leave for any of the other qualifying reasons, so there are 6 qualifying reasons. Again, we're going to talk about those in just a second. There are 6 qualifying reasons for the emergency paid sick leave, and I just said that intermittent use of that leave is only available if the leave is going to be for an employee to take care of his son or daughter. If the employee takes the emergency paid sick leave for any of the other qualifying reasons, the employee has to use the leave days consecutively until the employee no longer has a qualifying need or until the leave runs out. So just keep that in mind. Also, if the employer directs or permits the employee to telework, so work from home, then the employer and employee may agree that the employee can use the emergency paid sick leave intermittently in agreed upon increments of time, so half hour, 15-minute blocks, an hour and a half blocks, but only when the employee is unavailable to telework because of a COVID-19 reason. And when taken intermittently, only the amount of leave actually taken will be counted toward the employee's leave entitlement. Okay, let's go to the next slide and talk about the qualifying reasons for leave. There are 6 of them. The first is that the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. This includes a broad range of governmental orders, including the stay-at-home and shelter-in-place orders directed towards some or all citizens. We've seen these pop up in many states. We have one in Ohio, we have one in Michigan, we have one in West Virginia. Bob's going to talk about those statewide stay-at-home orders with particular emphasis on the one in Ohio a little bit later during the presentation. An employee who is subject to a quarantine or isolation order may only use the emergency paid sick leave if, but for being subject to that order, the employee would be able to perform work, either at the employee's workplace or at the employee's home under a remote work scenario. So if the emergency paid sick leave, will not be available to an employee because the employer has closed its business, even if that closure is due to the stay-at-home order. Even if the closure is due to the stay-at-home order, the emergency paid sick leave cannot be used because the employer doesn't have any work for the employee to do. So it has to be a scenario where, but for the order, he or she would be able to perform work at the employee's workplace or under a telework scenario. So it's going to be a very individualized basis. If there's a non-essential business that has closed its doors, the employee can't work for the employer. There's no hours for them to use. So there's no emergency paid sick leave benefit under those circumstances. Only if the individual is subject to the stay-at-home order, not the employer being subject to the stay-at-home order. The second qualifying reason for leave is that the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. So an employee may take the emergency paid sick leave based on a healthcare director to self-quarantine, but only if the healthcare provider advises the employee to self-quarantine based on a belief that the employee has COVID-19, the employee may have COVID-19, or the employee is particularly vulnerable to COVID-19, and following the advice of a healthcare provider prevents the employee from being able to work either at the employee's normal workplace or by telework. So if an employee is able to work from home, he or she may not take the paid leave, provided that 3 criteria are met: that the employer has work for the employee to perform, that the employer allows the employee to perform that work from home or another location where the employee is self-quarantined, and 3, there are no extenuating circumstances such as very serious symptoms that would prevent the employee from performing that work. Assuming that those 3 conditions are met, if the employer permits the employee to telework and the employee has that ability, they cannot take the emergency paid sick leave just because they're in quarantine. The third reason for the paid sick leave is that an employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis from a healthcare provider. An employee may take the emergency paid sick leave if the employee is experiencing symptoms such as fever, dry cough, shortness of breath, or any of the other symptoms that the CDC has told us are related to COVID-19. The leave will be limited to the time that the employee is actually unable to work because the employee is taking affirmative steps to obtain a medical diagnosis. So this includes making, waiting for, or attending an appointment with the individual's healthcare provider. It does not include self-quarantine without seeking a medical diagnosis. So if you have an employee who says, I have a fever, I have a cough, and I'm short of breath, I'm going to self-quarantine, that is not enough to trigger the emergency paid sick leave. They have to be seeking a medical diagnosis. If an employee is awaiting test results and is able to telework, they too cannot use the emergency paid sick leave, assuming that the telework conditions we discussed a moment ago are met. However, if the employee is unable to telework and they're awaiting test results, they can take the leave regardless of the severity of their symptoms while they're awaiting the test results if telework is not available. The fourth qualifying reason for leave is that the employee is caring for an individual who is subject to an order described in reasons 1 or 2 in your slide. So here we're looking at an employee who, but for the need to care for an individual, the employee would be able to perform work for the employer. So if the employer does not have work for that employee, then the employee is not eligible for the leave. Additionally, the employee must have a genuine need to care for the individual, and the individual being cared for must be an immediate family member, a roommate, or a similar type of person with whom the employee has a relationship that would create an expectation that the employee would care for that person. The employee cannot take the emergency paid sick leave if the employee is able to telework and the conditions for telework that we've already discussed are satisfied. The fifth reason to qualify for the emergency paid sick leave is that the employee is caring for his or her son or daughter whose school or place of care has been closed for a period of time, whether by order of a state or local official, or at the decision of the individual school or place of care, or the child care provider of such son or daughter is unavailable for reasons related to COVID-19. Here, the employee can take the leave if he or she needs to and actually is caring for the child, but only if no other suitable person is available to care for the child during the period of leave. If another suitable person, such as a co-parent, a co-guardian, another child care provider, is available to provide care to the child, then the employee does not have a need for leave. Also, the term son or daughter will include biological, adopted, or foster children. It also includes stepchildren, legal wards, or a child of a parent who's standing in loco parentis, meaning in the place of the parent, who's under the age of 18. It will include adult children 18 years of age or older if those children are incapable of self-care because of a mental or physical disability. The term child care provider means a provider who receives compensation for providing child care services on a regular basis. However, one thing that has changed since the previous presentations that Bob and I have given is that if the child care provider is a family member or friend who regularly cares for the child, those individuals do not need to be compensated or licensed to be considered a caregiver. And so those individuals, if they are now unavailable for reasons related to COVID-19, then that may trigger the emergency paid sick leave. The final reason for leave for the emergency paid sick leave is that the employee has a substantially similar condition as specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. Keep in mind here that we don't really have regulations related to this sixth reason. So we don't really know what these substantially similar conditions are as of right now, except what we do know is that the condition is one that is specified by the Secretary of Health and Human Services. As of right now, we don't have any such specified conditions, So there shouldn't be a leave request related to that right now. You'll notice that fear of contracting coronavirus is not a qualifying need for leave. So if an employee raises a fear of contracting the virus, saying they want to stay at home because they don't want to get the virus, that is not going to trigger the emergency paid sick leave. If an employer allows an employee to go on paid leave prior to the effective date, so if you gave leave to an employee the last week of March for one of these reasons, that employee will still be permitted to take the full amount of time permitted under the law as of April 1st. So just because you gave them leave earlier does not get you out of your obligation now to provide this leave. Basically, the law hit a reset button as of April 1st, and as of April 1st, if they have a qualifying reason for leave, they are eligible to the full amount of leave April 1st going forward. So no leave prior will be applied. If we go to the next slide, you'll see the rate of pay depends on the reason for leave. So the employee taking leave for reasons 1 through 3 on the previous slide, they get 100% of their average regular rate up to $511 per day, or $5,110 in the aggregate. If the employee is taking leave for reasons 4, 5, and 6 on the previous slide, they get 2/3 their average regular rate for those qualifying reasons, up to $200 per day or $2,000 in the aggregate. Simply because we're going through a ton of information in a short amount of time, I'm not going to get into the calculation of the average regular rate of pay, but if you need assistance with that, please call Bob or I to discuss. Keep in mind also that this is a single-use benefit only. So what does that mean? Once an employee has used his or her emergency paid sick leave benefit up to the 80 hours for full-time employees, that employee is not entitled to additional paid sick leave, even if it's for a different qualifying reason, even if the employee changes employers. If an employee uses some but not all of the emergency paid sick leave benefit and then changes employers, then the employee is entitled to the remaining portion of the emergency paid sick leave from the new employer, but is not entitled to the full amount. It would be lessened by whatever they've already used. But keep in mind, they don't have the 80 hours for every qualifying reason for leave. They get 80 hours and that's it. Once it's used, it's used. Let's go to the next slide and we'll talk about documentation and record keeping. The employee is required to provide employers with specific documentation substantiating the need for leave prior to taking the emergency paid sick leave. What does the employee have to provide? The employee has to provide his or her name, the dates for which the leave is requested, the reason for the leave, the qualifying reason for the leave, and an oral or written statement that the employee is unable to work because of that qualifying reason for leave. There are additional documentation that may be required to support tax credits, so keep that in mind. The employee must provide additional documentation as well, depending on the reason for the leave. So to take emergency paid sick leave because the employee is subject to a government mandated quarantine or isolation order, the employee has to provide the employer with the name of the governmental entity that issued the quarantine or isolation order. To take the emergency paid sick leave because the individual has been advised by a healthcare provider to self-quarantine, the employee has to provide the employer with the name of the healthcare provider. To take the leave for care of another individual who's covered, the employee has to provide the employer with either the name of the governmental entity or the healthcare provider that issued the order, as well as the individual who they're caring for. And then to take the emergency paid sick leave based on a school closure, the employee has to provide the name of the son or daughter being cared for, the name of the school or child care provider that has closed or become unavailable. And importantly, the employee has to make a representation that no other suitable person will be caring for the son or daughter during the period for which the employee takes the leave. This same documentation will be required also for the EFMLA, and Bob will talk about that in just a little bit. The employer may also request additional documentation, as I said, to support the need to request tax credits. An employer is not required to provide leave if documentation is insufficient to substantiate the applicable tax credit. The employer is required to retain all documentation for a period of 4 years, regardless of whether leave was granted or denied. If an employer accepted oral statements from an employee as opposed to written documentation to support the request for leave, then the employer has to document that request on its own and maintain that information as well in its records for 4 years. An employer that denies a leave request based on the small business exemption must also document and also has record-keeping obligations. They have to document the determination by the authorized officer that the employer is eligible for the exception, and they have to retain that documentation for 4 years. The employer must retain additional documentation for a period of 4 years in order to claim tax credits from the IRS, including how the employer determines the amount of paid sick leave, and that the employees were eligible for the credit, including records of work, telework, and has to document how the employer determines the amount of qualified health plan expenses that the employer allocated to wages, and then copies of any completed IRS Form 7200 that the employer submitted, copies of completed IRS Forms 941 that the employer submitted, and then any other documents needed to support the tax credit from IRS. And IRS is going to be issuing its own set of guidelines on this as well. If we go to the next slide, I want to talk briefly about healthcare coverage. An employer must maintain an employee's coverage under any group health plan while an employee is taking emergency paid sick leave on the same conditions as coverage would have been provided to the employee had the employee been continuously employed during the entire leave period. Maintenance of an individual policy purchased by an employee, though, is the responsibility of the employee. Plan changes will be fine as long as they are applied to all employees in the workforce, including those on leave, and the employer must provide the employee with notice of any opportunity to change plans or benefits. Keep in mind, though, that an employee on leave remains responsible for paying his or her portion of the group health plan premiums that had been paid by the employee prior to taking the leave. So the employee's share must be paid by the method normally used during any leave period, which likely will involve a payroll deduction. If the employee's leave is unpaid or the employee's pay during leave is insufficient to cover the employee's share of the premiums, then the employer may obtain payment from the employee through a number of other ways. It can have payment due at the same time as it would be made if by payroll deduction and have the employee pay the employer. It can be paid on the same schedule as payments are made under COBRA. It can be prepaid under a cafeteria plan at the employee's option. The employer's existing rules for payment by employees on leave without pay could be followed, provided that those rules do not require prepayment. And it can be another system that the employer and employee agree upon, which could include prepayment of premiums, assuming that the employee agrees. If we go to the next slide, we're going to talk briefly about job restoration. Keep in mind that employers are obligated to restore employees who take the emergency paid sick leave to an equivalent position upon their return to work. Employees are not protected, though, from other employment actions such as furloughs or layoffs, which would have affected the employee regardless of whether or not they took leave. If an employer wants to deny job restoration, the employer has to show that the employee would not otherwise have been employed at the time of reinstatement. So in other words, the employer has to show that the position was eliminated and there wouldn't have been a job regardless of the employee taking leave, or that there was a furlough or some other event that would make it so that the employee would not have otherwise had employment regardless of whether or not they took leave under the emergency paid sick leave provision. On the next slide, you'll see prohibited acts and penalties. So the employer is prohibited from disciplining, discharging, and discriminating or retaliating against any employee who takes leave under the emergency paid sick leave provision, or an employee who files a complaint or institutes a proceeding related to the use of the emergency paid sick leave. Violations of the emergency paid sick leave provision will result in a finding that the employer failed to pay minimum wages in violation of the Fair Labor Standards Act. So these employers are subject to the same penalties and enforcement mechanisms as the FLSA, which includes attorney's fees, it includes liquidated damages provisions, so the penalties can be steep. Keep in mind too that the Secretary of Labor does have investigative authority and subpoena authority under the emergency paid sick leave provision. So if the Secretary of Labor asks for documentation, you will have an obligation as employers to provide it. The next slide talks about notice obligations, and there are notice obligations for both the employee and the employer. An employer may require an employee to follow reasonable notice procedures after the first workday for which the employee takes emergency paid sick leave. Employees should notify employers about their request for emergency paid sick leave as soon as practicable. So that is the standard that we are using. If the need for leave is foreseeable, employees must notify employers about their request for emergency paid sick leave as soon as practicable. If an employee fails to give proper notice, the employer should provide the employee notice of the failure to provide notice and give that employee an opportunity to provide the required documentation to support their need for leave prior to actually denying the leave request. Notice may not be required in advance, but may only be required after the first workday for which an employee takes the emergency paid sick leave. Thereafter, it's going to be reasonable for an employer to require notice as soon as practicable based on the facts and circumstances of the individual case. Notice may also be given by the employee's spokesperson if the employee is unable to personally deliver the notice. Absent unusual circumstances, it will be considered reasonable for the employer to require the employee to comply with the employer's usual and customary notice and procedural requirements for requesting any type of leave, whether it's emergency paid sick leave or expanded FMLA. Employers also have a notice obligation, including employers that meet the small business exemption. All employers covered by the Act have to post and keep posted on their premises in a conspicuous place a notice explaining the paid leave provisions and providing information for employees on the procedures for filing complaints for violations of the Families First Coronavirus Response Act. An employer may email or direct mail the notice to employees. They can post it on an internal or external website that's available to the employees, and the employer may use DOL's poster or its own notice to fulfill the obligation. Translation is not required at this time. At this time, I'm going to pass it over to Bob to talk about the expanded FMLA provisions of the Families First Coronavirus Response Act. I can tell that I've already received a number of questions. You can keep texting or emailing your questions to me as Bob is presenting, and we will address those in just a little bit. So without further delay, Bob.
Thank you, Nadia. That was a lot to present and a lot to digest, as I certainly understand. But the good news is that Nadia's presentation makes it easier for all of us to understand the Emergency Family and Medical Leave Expansion Act, the EFMLA, because many of the provisions are the same or similar. and so I will not go through those again. So as you can see, the effective dates are the same. The employers impacted are the same. The employers excluded, she discussed healthcare and emergency responders, but let's speak briefly about employees less than 30 days, because if an employee has not been employed for 30 days, the employee is not going to have EFMLA available. Temp to hire type work counts, so temp time counts toward the 30 days. Even though employees with less than 30 days are not included, employees who are on layoff and were on layoff on or after March 1 are recalled are eligible if they are subsequently rehired through that recall. So there's an additional group that will be included. For those who wrestle with the FMLA all the time, the traditional 12 months, 1,250 hours, and the other requirements just are not there any longer. The small business exemption is, as Nadia mentioned it, with 3 criteria. But in our all I want to say with respect to this is our analysis leads us to conclude that this exemption is more narrow than many employers would hope. And so you definitely need to look at the 3 criteria to determine whether you're going to enjoy that small business exemption. The qualifying event is only one. The FMLA, the emergency FMLA, only has one circumstance in which you can avail yourself of it, and that is because you're unable to work due to a need for leave to care for a son or daughter. And of course, the son and daughter has a broad definition which has been captured from the traditional FMLA, and you should pay attention to that. The takeaway here is if an employer wants to be discerning and strictly construe this law, when that employee walks into your door, there's an analysis that has to be done. There has to be some questions asked, and I know it sounds pretty basic, but first of all, is this really a son or daughter to get started with? The first day this law went into effect, April 1, one of the companies we work with had 8 people standing out the door of the HR department, and they all had information ready to use and abuse these provisions. So determine what philosophy you want to take with respect to being discerning about application of the requirements. The expanded FMLA benefit is 12 weeks for leave. That intermittent leave arrangement is only by agreement, as Nadia mentioned. The first 2 weeks of the 12 weeks will be unpaid, but you can utilize, the employee may utilize the sick leave, the EPSL, for the 80 hours worth for the first 2 weeks in order to obtain compensation. The rate for the leave is 2/3 of the average regular rate, and that's a defined term, and so you'll get that 2/3 for those 10 weeks. There's a max involved, however, and that's $200 a day or $10,000 maximum for the entire period of the leave. Now, a couple other things to remember here. Employees can demand and employers can require that existing PTO arrangements in the company be used to supplement this emergency FMLA. So the payments are at 2/3 the average rate, but employees could ask that whatever monies they are entitled to under the PTO policy of the company could be used to supplement that shortfall. But the eligibility for tax credits still are limited to $200 per day, $10,000 for the entire period. If something else to remember is that if the FMLA, the emergency FMLA, is used concurrently with other PTO, the employer must pay the full amount of the entitlement for the period of the leave, even if that amount is greater than the 2/3. So there's some tricks here in how you're going to interface your PTO with the FMLA. So be careful of that. The healthcare benefits are, as Nadia mentioned, the healthcare coverage continues. The premiums are shared by the normal methods, and payment is recaptured by the employer as traditionally is done. The leave documentation is the same. And the takeaway here that I want to add is that employers who wish to be discerning about this need to do some fairly significant cross-examination of the employee. I know that under traditional FMLA, the employee walks in with a certification of healthcare form, and that particular form is just about all you're going to get as far as information. But the traditional FMLA forms are not in play here, and the regulations so state. So you're entitled to do a little more to get sufficient information to determine whether the request is bona fide or not. And one such item, of course, is that certification that no other suitable person will be caring for the son or daughter. So the interesting event, of course, is that the employee has been coming to work for 3 weeks, and she, for example, has been working while her husband is at home taking care of the 2 kids. And then all of a sudden on April 1 came the enactment of this FMLA extension, and all of a sudden that woman who works for you needs to stay home with the kids. Is that really true? Is there another suitable person there? This is something that I think you need to wrestle with. Now, some employers will take a fairly laissez-faire approach and say, no, we'll just go ahead and be fairly reasonable about this. Others will say, look, if we open the floodgates to this, we'll have no one here working in a short period of time. The employee's reinstatement reinstatement after leave, it's to a same or equivalent position unless the job no longer exists. So if that job ends during the course of the leave for various reasons, there is no reinstatement. There's a provision where you can deny reinstatement to certain key employees, and the definition of key employee is set out, but it's not for this presentation. Another interesting aspect of the FMLA is that the reinstatement may be denied by employers with less than 25 employees due to a hardship, but all of the conditions must be met, and here are the conditions there. The position no longer exists for the COVID-19 reasons or economic reasons. The reasonable efforts to restore the person to a same or equivalent position just didn't work out, and the reasonable efforts to restore didn't work out after the employer made contact with the employees over a 1-year period. So this particular quirk in the EFMLA denying reinstatement is not very broad. And if you utilize it, then there has to be an actual certification or written documentation by an authorized officer as to all of these conditions. The record-keeping provisions remain the same as Nadia referenced them. The IRS Form 720 is the advance payment of employer credits. And that's where you have a deposit shortfall. In other words, you're offsetting these payments you make to the taxes being remitted. The Form 7200 is used when there's not enough to offset, for those who did not know what the 7200 was. We have posting requirements. We have the same prohibitions about no discrimination, interference, or retaliation with the employees exercising their rights. We have a fairly substantial amount of penalties. Now let's talk briefly before we leave FMLA on the interaction with regular FMLA, because don't forget that the regular FMLA is still in play, and we have employees who have attempted to use the EFMLA and the EPSL unsuccessfully because they have not qualified, and then they turn their sights to trying to fashion some type of leave under the traditional FMLA, which they are entitled to do. So keep that in mind. The FMLA leave of the 12 weeks it interacts with the emergency FMLA. So if you use some of your traditional FMLA during the 12-month period that exists, and then you want to use the emergency FMLA, the total combined is still 12 weeks, and vice versa as well. You need to keep in mind the interaction of the FMLA. Let's change the topic to the state-based stay-at-home orders. And I have reviewed those for several states, and most of those are about the same. West Virginia, Ohio, and some of the other neighboring states are pretty much the same. And there's only a handful of states now which have not implemented it. The order in Ohio was changed yesterday by the Department of Health, Amy Acton, at the request of the governor, and it becomes effective on April 6th and extends now the shutdown order until May 1. It includes recreational activities, and that includes things like sports tournaments and organized leagues. So those of you playing in baseball and golf leagues, I think your days of fun have come to an end. Even though these are outside sports, it's covered. There are also provisions now that if you travel into Ohio, you need to self-quarantine for 14 days. Social distancing is the same. It hasn't changed in the language of the agreement. Social distancing is distancing as much as possible. It is not an absolute requirement, and if the employer cannot accord the social distancing, then all of the employees go home. That is not the case. With respect to penalties, they brought forward the penalties into the new order, but they were already in existence, but they published them, I think, to scare people. Maximum $750 for the criminal misconduct in 90 days. Essential business operations still are exempted under the same provisions as you see. And I heard on the news this morning a reporter talking about that this new order requires now that the maximum capacity of any store would be 10 individuals, and that therefore there's going to be some curtailment of activities. That is not right. The maximum capacity is what the store sets. The store determines it with respect to its conditions, and then it must post. But the guiding principle is that the capacity has to be regulated by an assumption that each patron would have at least 6 feet of social distancing. And of course, we now have learned that the partial shutdown orders of various states are considered to be quarantine or isolation orders as well. I want to do a wage hour clarification here because in our prior webinars, we discussed general wage hour rules, and time did not permit anything other than the general rules. One such rule was that employers are only paid for hours actually worked, so you don't have to pay for employees when you send them home and don't request that they perform any work at home. I also advanced the general rule that salaried, exempt, white-collar employees must be paid for their regular weekly salary, even if sent home by an employer during the work week. While this is a well-established rule that has been in effect forever, there is an exception to this. And so we got talking about what about an employer reducing a salaried employee maybe to 4 days a week and paying 4/5 of the salary. The general rule says you can't do that, but there is an exception, at least one exception that I want to bring to your attention that would permit you to do that. A fixed reduction in salary and hours effective during a continuing period for a unique and bona fide business reason is permissible as long as it continues for the entire period and the employee is paid at least the statutory minimum of a salaried exempt person, which is now $684 per week. So a bona fide reduction is not something designed to circumvent the salary basis requirements. So if an employer, this rule was designed so that employers don't flip back and forth depending upon what week it is to try to work an exempt employee a bunch of overtime and not pay them. I bring to your attention that this exception is a permissible situation under these circumstances. Also, you can deduct one or more full days of pay if an employee voluntarily, a salaried exempt employee voluntarily agrees to go home. But you would do so on a full day basis, and it must be voluntary. Also, there's a provision now in the regulations that say that nothing in this act should be construed as impacting an employee's exempt status under the FLSA. This was primarily put in there to talk about intermittent leave, and if a salaried employee took off one day on an intermittent leave situation, are you going to blow the salaried exemption, white-collar exemption? And the answer is no. But this language also shows the intent of the Department of Labor. So I think we're safe to say that if you change the salaried exempts to less than a full week and less than a full pay, but resume after this crisis is over, this pandemic is over, you'll be fine. Before you have an article we wrote some time ago, which is the workplace do's and don'ts, which covers a lot of the nuts and bolts on how employers should address all of these issues. And if you're not on their mailing list, would be happy to address that, send one out to you. Also, there is a comprehensive summary of what we talked about today that has been prepared by Nadia, and I think it's one of the best summaries you can get your hands on. This summarizes in a few short pages 124 pages of regulations, questions and answers, and the integration of other laws. Before we take questions, I wish to invite you to our website for further information. If we can be of assistance to you at TAF, we would welcome the opportunity. We have a large number of labor and employment law attorneys and business attorneys who are well versed on coronavirus issues. We have the TAF law dashboard, which contains all kind of information employers and businesses must address with respect to the coronavirus situation. So with that, I'll turn it to Nadia on the questions and answers.
Thank you, Bob. We have received a number of questions, so we're going to try to get through as many as we can in the next 10 minutes or so. The first question, if an employee is currently laid off because a job site closed down because of COVID-19 prior to April 1st and we have no other work, is the employee entitled to sick leave pay as of April 1st? And the answer to that is no. The applicability of the law is the analysis is going to start at the time an employee would take leave. So the law doesn't take effect until April 1st. We assess the 500 employee count and everything else at the time an employee would take leave. So the leave here would be requested April 1st. Or going forward, and if the employee is laid off as of that day and there's no work to be done, then they're not eligible for the paid sick leave or the expanded FMLA. The next question, if someone was quarantined for suspected COVID-19, they were tested but came back negative, does the sick leave still apply for the 80 hours? And the answer there is that they are eligible for the amount of time that they actively were engaged in seeking medical diagnosis. If they cannot telework while they're awaiting results, then they would get that time. They would be eligible for that time. When the test comes back negative, though, from that point forward, let's say the test comes back negative in 2 days. They don't get the full amount of time, the full 80 hours. Once it comes back negative, they would need to return to work. So if, say they used 20 hours, but they were eligible for 80, the negative test result came back after 20 hours, they're only entitled to the 20 hours and then they need to come back. Next question, what can we do if an employee refuses to return to work because they fear coronavirus? Bob, do you want to take that one?
Yes, that's the old general fear situation. And the mere fact that the employee has a general fear will not be sufficient. And that would be a situation where the employee could be terminated if the employee with that general fear chooses to stay at home and boycott the company. That employee, if you accept the employee being off, they have voluntarily absenced themselves from the workplace and therefore would not be qualified for either state unemployment or the federal CARES Act $600 unemployment that lays on top.
Okay, what do we do when an employee flat out refuses to work in the construction field because they feel unsafe? They do, though, expect to be paid while at home and not use their PTO. Some say they will file for unemployment. I think you just answered that, Bob. Do you have any other thoughts that you want to share?
I know that this is happening in the construction industry, and to a significant extent. We've had a large number of workers walk off of a few jobs, and the situation has to also be taken into consideration, though, what we spoke of in prior presentations to you. There is a OSHA section 13 that talks about imminent danger, but I do not, and that permits an employee to absent themselves from the workplace because of an imminent threat. I don't consider the general fear to be the imminent threat. If you had, however, several employees on the job site come down with COVID-19, maybe that imminent threat would be there unless and until the employer came in and decontaminated the facility and then put the employees back to work. But they certainly, if they're going to voluntarily absence themselves, they're not going to be entitled to the benefits.
Okay, we have had several requests for the slides and the presentation. If you have sent me an email or a text about that, rest assured we will have those materials available to you at the end of the presentation.
In addition to that, Nadia, there are several trade associations participating in this presentation, and so we will also forward that information to those trade associations so they can have that information readily available for their members, including reproduction of the entire presentation.
Okay, next question. If an immunocompromised employee has been directed by their doctor to quarantine due to risk of contracting COVID-19 from coworkers, does that qualify for sick leave? And the answer is probably. Based on the qualifying reason for leave number 2 on the slide, an employee can take the EPSL based on a healthcare directive to self-quarantine. But keep in mind here that if the employee is able to telework, and the employer can offer the employee that remote work arrangement, then they wouldn't necessarily be entitled to the leave. So you'll have to look at your telework arrangement there too. But then again, also keep in mind that if the person has some extenuating circumstances like very serious COVID-19 symptoms or something like that that would prevent them from teleworking, then the telework option would not be applicable. Next question is
Nadia, if I may,
yeah.
there's a traditional FMLA twist on this, and I talked to you earlier about the fact that employees are smart enough to try to work the regular traditional FMLA if they can't come under the various reasons for EPSL and EFMLA. So what they may very well do is to say that their spouse has asthma and is at home and it has flared up and the doctor has told them not to work because of possible exposure to COVID-19, and therefore the spouse at home has a serious health condition and the other employee actively working needs to care for that individual and go home. So that doesn't necessarily mean that it would meet all the requirements if you had them get out the certification of healthcare provider form and do all the rest. But I'm telling you that is how the gaming is going on. So be careful of that interplay between EFMLA and just traditional FMLA.
And feel free to follow your traditional requirements for the traditional FMLA process in requiring the certification and everything else. You don't need to just approve that at the outset without following your traditional steps.
And we did not mention that we have developed some forms with respect to employees requesting these paid leaves that we talked about here today. I strongly urge you to have some form to be used, and also there's a provision that says when the employee is making this request, if it's oral, it should be reduced to writing and memorialized and kept for the 4 years. My position is it should not be oral at all. It should be you got to get these employees to write out the reasons so that you can make sure that you got qualifying reasons and make sure that in the event in the next 4 years somebody comes in to audit your records, you can actually prove the reasons for why someone took time off.
Okay, next question. Does a girlfriend or boyfriend's child fall under the watching children reason for leave? And in this one, I would say probably not, but it's possible. Remember that the need for leave is to care for a son or daughter. And the definition of son or daughter means a biological, adopted, or foster child, or a stepchild, a legal ward, or a child of a person standing in the place of a parent. It's possible that a girlfriend or boyfriend could be standing in the place of a parent, but unlikely if the actual parent is involved in the raising of the children, so it's probably unlikely. And so if an employee comes to you and says, I need to take leave to care for my girlfriend's children or my boyfriend's children, that you're going to have to ask some follow-up questions to see if they're standing in loco parentis of the girlfriend or boyfriend, but it's highly unlikely that that would trigger the emergency paid sick leave or the emergency FMLA. If you are an essential business and you have job sites closed because where they work closed, do you qualify for the sick leave? Let me read that again because that's a little confusing. So if you're an essential business and you have a job site that has closed, does the employee qualify for the sick leave? Bob? Well, let's just go through here. If the
we're in the
job
but
site
for.
has been
We're in the
closed,
but for test is what we're into there.
Yeah, if the employee is working at the facility where the job site has closed, then they don't have any work for the employee to perform, and so the employee would not qualify for the sick leave. If the essential business has a facility that has remained open, then the employees who are working in that facility may be eligible for the sick leave if they have a qualifying reason. So that's the answer to that one. The next question, as of what date do I determine if I am over or under 500 employees? And I think we addressed that a little bit earlier. It's at the time an employee would take the leave. So for example, you could have an employee that takes leave based on, let's say, advice from a healthcare provider to self-quarantine on April 4th. And then you have a reduction in your workforce on April 5th, and you go under the 500 employee threshold. If someone comes to you the next day and wants to take leave for the exact same reason, you can deny the leave because you are no longer considered a covered employee because you, say you did a hiring, not a reduction in force. So you would be over that 500 employee threshold, and so you could deny the leave at that time.
But any of the employees, go ahead, Nadia.
Even if it is for the same reason. But any of the employees that are currently out on leave, you'd have to honor theirs, but you wouldn't take any additional leave requests moving forward. Next question, how are we supposed to know if there is or isn't another qualified person to watch an employee's child? If an employee wants to stay home with their child, they aren't going to tell an employer that they have other people as options. Are we allowed to ask so we can determine if they qualified for the paid sick leave? This is a great question because it really does just highlight the potential for abuse with these provisions. And I would say here that this gets to the documentation and record keeping provisions. I would say absolutely you can ask because remember that one of the things that the parent has to say when they want to take leave related to caring for their child is they have to make a representation that no other suitable person will be caring for the son or daughter during the period for which the employee takes the leave. And you'll want to have the employee sign that statement. And they certainly would not want to make an untrue statement or a fraudulent statement. You can certainly ask them because they have to make that representation to you that no other suitable person can care for the children. Next question, how is it determined or verified when two parents could care for a child or children for a COVID-19 school closure? Is it the parent's choice? How is it verified? Which is the designated parent? This is another great question. Bob and I have wrestled with it a number of times. Really, there is no regulation that addresses how to determine which parent would get the leave or which is there is no designated parent, so to speak. Either parent can assuming all other qualifications are met, either parent could take the leave, but likely not both, because remember, there has to be a need for leave to take care of the children. So the only scenario that I can really envision where you would have two parents needing to take the leave would be if you had children who had special needs, or children with disabilities where there's a heightened need for care. You may have a situation where both parents would need to be home because maybe you have one special needs child and then one or two other children that aren't special needs, and so you just kind of need more hands on deck. In that situation, you might have two parents that would need to take leave, but otherwise you wouldn't. In my household, we're a blended family. We have 5 children, and there are days that I think we need 3 or 4 adults in the room. But unfortunately, absent some specialized circumstance like special needs or something like that, a disability, there's probably not going to be a need for 2 parents in the home. But the regulations are really silent on how you would go about verifying or designating which parent, other than you can ask the questions, is there someone else at home, that sort of thing. And you can, if there is somebody else at home and you don't see extenuating circumstances that would substantiate a need for the leave, you can deny the leave. If there is another suitable person at home caring for the children. Go ahead, Bob, you were going to say something.
Yes, Nadia, this goes back to what I presented earlier, where we've had school shut down now for several weeks, and there's a certain method of operation where one employee's been coming to work and the other one's staying at home with the children. And so if all of a sudden that person that has come to work every day for you sees that the law has changed on April 1 and all of a sudden has to go home, you certainly want to ask them what has changed that requires you to now be at home with the children because somebody else, your spouse, was taking care of the child or children during the prior period. So nothing wrong with a little interactive process, so to speak, to try to get to the desired answers.
Okay. If an employee lives in the same household as someone who is high risk, does that person have a qualifying reason for leave? And the answer there is no. Without something more, just living with someone who's high risk does not qualify the person for leave. If, however, the employee is taking care of someone who's subject to a self-quarantine order from a healthcare provider because of COVID-19, then they would trigger the EPSL. And again, you'd have the same scenario here that Bob and I talked about earlier, where there's the traditional FMLA that could come into play if the employee wants to go that route. But your traditional certification and your traditional process for FMLA would come into play there. We offer our employees PTO. When they take one of these qualifying reasons for leave, can we require them to take the PTO first, or is the paid time off in addition to what we currently are offering them? And it's a little bit different for there's a little bit more option with the FMLA, the EFMLA than the EPSL, but the general rule is that you cannot, as the employer, require the employee to take their accrued PTO before taking the emergency paid sick leave benefit. The benefit is in addition to, not instead of what they're currently offered through the employer. They can, at their option, elect to take PTO to make themselves whole. For example, if they're getting 2/3 pay as part of the benefit, they can elect to take accrued PTO or other leave under an existing policy to get 100% of their pay, but the employer cannot require the employee to take the PTO instead of the paid sick leave benefit. For the notice posting, is posting on an employee intranet acceptable? Yes, that is acceptable. If an employee changes jobs and used the paid EFMLA at their previous job, are they entitled to another 12 weeks after 30 days with the new employer? And the answer is no. These are single-use benefits. Can an employer verbally ask an employee for proper notice for time off? And can an employer verbally request proper documentation for the requested time off? The answer here is yes, you can verbally ask for the proper notice and for the proper documentation. But I would suggest to you that it's beneficial to document these requests. And the reason for that is if we fast forward 6 months or a year and you end up having investigations or you end up having an employee complaint, it's likely that right now you're going to be inundated with these requests and you're probably not going to remember every conversation you had related to these. Obviously, you have to document any decisions that are made with respect to the leave, but you can verbally ask an employee to give you proper notice. You can verbally ask for proper documentation, but I suggest to you that you should probably document those requests as well, just so that you have them for future investigative needs. Bob, someone has asked for you to expand on social distancing, specifically related to your comment that employers are obligated to implement where possible.
Sure. This is a highly controversial matter, but if you look at the order, for example, in Ohio, it talks about where possible and as possible, and it is not an absolute. So while it's important that each person exercise social distancing at 6 feet or more to the greatest extent possible, it isn't a prerequisite to an employer continuing its operations. The employer doesn't have to guarantee 6 feet. The perfect example is in the construction industry. If you're doing some type of HVAC duct work, and it takes 2 people to handle the duct and to put it up in the ceiling and bolt it to the ceiling, the 6 feet cannot necessarily be maintained, but that doesn't mean that the 2 sheet metal workers are then entitled to walk off the job and not to perform work. I would hasten to say that the governor and Amy Acton, the head of the Department of Health in Ohio, are strong advocates of the 6 feet social distancing, and if employers don't try their very best to ensure this, I'm fearful that the next shutdown order in the state of Ohio, as well as other states, will shut down essential businesses such as construction. So to the greatest extent possible, the 6 feet should be utilized, but it is not an absolute.
Thank you, Bob. We have some other questions. One question is the morning of the requested day off sufficient notice? And I would say generally that's probably not, but it really depends on the facts and circumstances related to the request. So if an employee comes to you and says they're symptomatic and need to be tested, then yeah, that's sufficient notice. You don't want that employee in your workforce anyways, potentially infecting other individuals, and so they're going to go and seek a medical diagnosis. If it's for leave to care for a child, and as Bob said, we have been dealing with this public health emergency for the last 3 weeks, that need for leave was foreseeable likely, unless some emergency event occurred, in the last 24 hours. And so a little bit more notice would have been proper under the circumstances. So it's going to be a fact-intensive, case-by-case analysis. to determine how much notice. I will say that the Department of Labor is strongly encouraging employees and employers to work together in all aspects of these new laws, but with particular respect to the notice provisions, they are not very strongly worded to say that an employee has to give a specific amount of time in their notice. As soon as practicable is not a very high standard. And the regulations are also very forgiving in the sense that if an employee fails to give proper notice, the employer's response is that the employer needs to give the employee an opportunity to provide the required documentation and an opportunity to correct the failure prior to denying any leave. So it's going to be a case-by-case analysis, but you're likely not going to deny leave on that basis.
And the regulations address that, where they say notice may not be required in advance, but may only be required after the first workday for which the employee takes EFMLA. Thereafter, it will be reasonable for an employer to require notice as soon as practicable based on the facts and circumstances. So there's almost when you pull up sick on a given day, you're at least given a 1 day grace period with respect to notice.
Okay, another question. What is the fear to return to work? So fear related to coronavirus. What if the fear is because of a health condition such as asthma? And again, we've been getting a lot of questions about people not wanting to report to work because of fear related to the coronavirus. I would again point you to the qualifying reasons for leave. Even if a person has asthma or another condition that maybe makes them a little bit more susceptible to coronavirus, they need to be directed by a healthcare provider to self-quarantine or be seeking a medical diagnosis related to coronavirus before they're going to trigger the emergency paid sick leave provision. So fear alone is not going to trigger the paid sick leave provision. Okay, next question, and this is a good one for you, Bob. I like this question. The construction union's business agent is handing out the COVID-19 unemployment codes like Tic Tacs and wrongfully informing their members. How do we stop this? Do we have grievance rights against the union for interfering with our workforce?
All right. Well, first of all, under most collective bargaining agreements, the business agents and business managers have the right to be on the work site in order to police the compliance with the collective bargaining agreement. So we're not going to be able to, under most circumstances, we can't stop a BA or a BM from being on the project unless it's an owner-mandated requirement that visitors are not allowed on the work site. With respect to passing out bad information, we can't stop whatever information is provided. So if it's bad, it's bad. It's unfortunate that what the business agent or manager is doing is enticing employees to not work and to instead absent themselves and get state and federal unemployment, which probably will be just about as much as they would earn on any given day. I think a discussion with the union representatives about that would be warranted. I may even try to argue that it in a way is a violation of the no strike, no lockout provisions, in that it's almost as if the business manager is enticing the employees to walk off the job instead of performing work. So you have to be a little innovative there. But there are basic rights guaranteed by the National Labor Relations Act to union representatives. Okay,
if an employee says, lay me off, do we have to honor or should we just let them quit? You do not have to honor an employee's request to lay them off. Whether or not you just let them quit, that's going to be a business determination on your end if you want that employee around or not. We are a small company. Who do we contact about exemption from the sick time off due to hardship so we have it documented? This, as of right now, it seems to be that this is a documentation, self-regulated process. DOL does not want you to submit any documentation directly to the Department of Labor at this time, but you do need to retain the documentation of an authorized officer making the decision and determining that one of the 3 conditions is satisfied for the small business exemption. And then if any employee requests leave, you need to document the denial for each of those instances as well. And that documentation has to be retained for 4 years. If you need further guidance on whether or not one of those 3 conditions are met, Bob and I are happy to be of service to you and to go through that process with you. But it's a self-regulation as of right now. Bob, it is 11:30. We have probably dozens more questions. Unfortunately, we just don't have the time to address every single one. But Bob and I are happy to be of further service to you if you reach out to us directly. And I'll hand it over to you, Bob, for some other closing remarks.
Well, thank you, Nadia. Very good job today, and we certainly appreciate all of you attending not only this presentation, but the other presentations in the past. We do not intend to have webinars and publish information just for the sheer heck of it. If there is a development in the future you need to know, we will make that information available to you if and when the time arises. In the meantime, if your business desires additional advice, we would be happy to have you as a client of the firm. We have attorneys near you, no matter where you are. We have over 600 attorneys in 9 cities and 6 states, so we would be happy to represent you in these COVID-19 matters as well as any other matters, legal matters you may need service. Thank you for attending. Have a good day, and please be safe.